Politicians inherit a huge amount of power when they enter into office. Not allowing them to gag the media is the least we can do to balancing the scale. The first thing I want to do is some setup. What we think the tort of defamation is three things. We firstly think this looks like things like reputational damage. Like, for example, in the law, you have to prove that as a politician, you suffered as a cause of this defamation suit that you're doing. Secondly, there's just an evidentiary burden on the claimant. For example, like the claimant needs to prove why the stuff they're saying is actually untrue, and we'll explain why this is important later. But lastly, we just want to note that, like, obviously instances of things like hate speech fall out of the debate that would fall under normal things like criminal law. This is just about defamation. First argument then on why this is a valid thing to give up. This argument is going to explain that the scales towards politicians are already so heavily tilted in their favor that there is a necessity to try and tilt these scales back towards the common people. First thing under this is that I think as a politician, you've willingly opted into and consented to losing some rights, essentially. For example, I think this is quite a normal thing for people to do. When you enter an NDA, you lose a certain amount of rights by entering this contract. If you decide to enter politics, we think it is a justified thing for you to lose some certain rights. Especially because secondly, you gain a large amount of pretty significant and positive rights. For example, politicians gain immunity by being prosecuted while in office, and the point of this is to demonstrate that the legal system is already skewed quite in favor of these politicians. Like, they gain legal immunity from being prosecuted while in office, so you shouldn't take away the fact that the media can criticize them in ways. Thirdly, I think even if you think that you don't get that balance within legal rights, I think you do just get a balance of like power in general, because you do gain just so much power from being in office. You gain things like money and connections and access to how the laws in your country or policies in your country are implemented. For example, we just do recognize that there needs to be some sort of balancing of the scale generally in the how much power is given to the government. For example, we often give things like an inherent right to judicial review in certain policies. So this is just explained why there is a positive necessity to try and reduce these scales a little bit, and why it's an important policy. Second argument then on why we think this improves politics generally. The first part of this argument is to explain why defamation is unfairly easy for politicians to succeed in. Firstly, we think it's because politicians can too easily explain why their reputation is damaged. For example, you can say like, oh, they've like fucked over my election prospects and this is unfair. But the reason we think a politician's reputation getting damaged is distinct from a normal person's reputation getting damaged is because politicians trade in their reputation. So really this is just like someone being held accountable rather than like a random person getting a defamation case and it like actually like harms their life in a more significant extent because they haven't consented into the fact that their reputation is their trade and currency descendant is much more damaging, where we think it's different for politicians. Secondly, we think politicians just have a huge amount of legal power in comparison to the person. This looks like three things. Firstly, it's like having access to the best lawyers in the country, and this isn't even just in terms of having money and connections. This is oftentimes while you're in office. So you have access to things like the Solicitor General to represent you. You have access to lawyers and companies that have time. And think in comparison to a lot of like other media companies, especially small media companies who are likely to be most critical of politicians, they just do not have that time comparatively. Legal power is so skewed in favor of politicians. But secondly, they also just have powers in the system. Like the government and politicians appoint judges and make recommendations on what judges should be appointed. Like a lot of people, lawyers don't want to screw them over. But secondly, even if you don't believe they would engage in some form of corruption, which we think for a set of politicians is probably true, they just understand most of the time in non-corrupt ways how the system works. Like who the best judge is to go to, or like who is the lawyer that specifically is really good at getting politicians out of this situation. This is a level of asymmetric power that a lot of the time these media companies do not have. Secondly then, on why we think that discourse is stifled in an unfair way. Firstly, we just think a lot of institutions there's a massive chilling effect around defamation cases, because a lot of institutions just can't afford to get into long and dragged like defamation cases, which means that they are overly cautious on what they are actually reporting. And this is important because even if they do turn out to be successful in these defamation cases, a lot of the times the reporters involved or the media companies are just ruined for the rest of their life Think of Lisa Wilkinson from Channel 10, who even if their defamation case was successful, her reputation as a journalist was ruined for years. This means that media companies are too cautious about publishing stories that could be useful in a way that is incredibly bad, which removes a lot of media companies from publishing stories they otherwise have. Secondly, though, we think that even if you believe that some of these cases will be successful in the future, there's a lot of things that the politicians can do in the process of these legal cases, which mean that you get like discourse stifled in general. These look like things like gag orders. These look like things like extending the case out a lot of the time. So even if it is proved it is not defamation, you have huge silencing power in the years in the midterm, which can affect things like elections and knowledge generally. But lastly, we also just think they just do tend to skew to be successful towards the politicians regardless, because it's like much easier for you to like actually, it's much more difficult to prove, for example, that you actually have like something that is true, because we think a lot of the cases that this occurs in is, for example, it's like small newspapers saying like, oh, this politician could have links to corruption in here, and this is important, and these cases should be like exist generally, because oftentimes you do need to publish those stories for it to be like proved whether or not it's true or not. Like you need more people to see that story to come out and add extra stories to see if this like the politician is corrupt or there is something there, or make the story not to die. But we think in their world, this means that the politician is just going to like immediately silence these stories and just try and defame them. And we don't think these stories then get published because, as I've already explained, a lot of these companies don't want to risk going into the sort of media storm that could ruin these reporters and companies' reputation for the rest of their lives. Why is this important? Firstly, I just think it means that you do not get hugely important stories about corruption that politicians are engaging in or other like bad stuff that a lot of these people are figuring it out in the public. Because discourse itself is inherently important. You need people like knowing inklings of information for more people to come out. Oftentimes information is incredibly dispersed. You don't have like one media company that is just like figuring all this shit out and they can come out with like all the evidence and defend themselves with a defamation case. You need multiple people coming out and information collected over time for it to be an impactful story. And this is important because it means that you don't get these opportunities. You get information science and discourse by these defamation cases. This is much worse. But secondly, this just allows for the publication of stories that otherwise would have been silenced. And like as we've already explained, a lot of the times these stories are often very good. So we think this is a positive benefit that these stories are benefit. Lastly then, I'll just like preempting like the claim about, oh, what about like some of like the bad shit and like what if these stories are actually bad. Firstly, we just think bad articles are just like pretty easy to deal with. Like if someone is claiming really unfairly that like you're a pedophile or something, you can just like kind of claim, no you're not, here is a lot of evidence. Like the worst shit is easy to deal with. But secondly, oftentimes like the stuff like, for example, if a politician is trying to defame another politician, a lot of the times that's the easiest stuff to get around. Because the thing that is most impactful for people not publishing the important stories we've talked about is the chilling effect on these media companies, such that they don't want to get dragged in. But most of the time, politicians have the same benefits and access that we talk about, so they don't give a shit, and they're just going to keep talking shit about you, no matter what. So this doesn't actually like affect political discourse between politicians in a way that is better. But lastly, but oftentimes, it's like the thing that is like sling mud shit, it's like exaggerations of the truth. Like saying that like Joe Biden is like Sleepy Joe is like obviously an exaggeration, but it is like an exaggeration of the truth that like he's a little bit brain dead. So that's sort of defamation still exists. Very proud to affirm.
Thank you very much for the speech. We now welcome the second affirmative speaker in the case of you're here.
Defamation was never designed to prevent smear campaigns. Because as we explained from first, the most effective smear campaigns are those that take a piece, true information about a politician, and exaggerate it and highlight it. They focus on the fact that, for instance, the politician's child may be a drug addict. They're focused on the fact that the politician may have a potentially shady background. These are not the things that matter in elections, but the things that are very easy for powerful politicians to highlight. And side negative proves to you why defamation is bad at addressing these things. Because as first negative says, these politicians are still owned by the smear campaign during the proceedings. This proves that they do not stop any of the harms of smear campaigns, because if it was brought by a politician that has a lot of power, that has a lot of ability to talk and continue to do that smear campaign, and who will win the defamation proceeding because they are only talking about things which are provably true, this will not solve their problem. But they do not rebut the harm that we explain, because we explain that defamation is uniquely effective at censoring the most important forms of discourse. That which is brought by small institutions that can't sit through years and years of proceedings that are ludicrously expensive. That as the first negative says, no one wants to sit through those long proceedings. They cannot take the reputational damage in that time because they will go bankrupt and they will be shut down. These are the benefits that you miss out on. The first thing I'm going to explain in this speech is why politicians do not deserve the right to defamation cases, and prove rather why as a principal benefit they ought to be stripped of that right. Then explain why they do not stop the kinds of harmful information they want to, and finally explain why they do censor important discourse. First of all, Affirmative gives you 3 reasons to attempt to explain why politicians deserve to bring defamation to proceedings. The first they name is that the harms are simply unacceptable because politicians need their reputation. We would explain neatly, this is the reason they do not deserve to bring defamation to proceedings. Because for normal people, reputation is something which we would believe they are entitled to, given that it is auxiliary to their normal life and something that they enjoy on a day-to-day. The problem is that politicians trade in their reputation. The fact that people think of politicians as good, the fact that they have this reputation, is how politicians entitle themselves to extraordinary coercive power over society. The fact they can throw people in jail, the fact they can make laws. The problem is, the laws that are made by politicians should not themselves protect the reputation that politicians use to keep themselves in power. It's the circularity of control that is afforded by defamation proceedings when politicians who need their reputation can themselves take it into their own hands, protecting that reputation, is exactly why there's undue and unfair legal power which is afforded to politicians on side negative. Second of all, negative says that you cannot disprove defamatory claims when they're brought up. We would explain, first of all, if this is true, this is why their defamation proceedings are not even an effective gag on these. But second of all, we would explain further that you simply can disprove the worst kinds of defamatory proceedings in other ways. It's unclear why, as they say, an extraordinarily long court proceeding against an allegedly rich defendant, that is the other politician that they think is the biggest wrongdoer in this debate, is an effective way of shutting down discourse. It is not an effective protection. Finally, they say that they need this protection because the stakes are higher and it changes voting, but this is our case, because we would explain that you ought, as a principle, prioritize caution when regarding politicians. It is far preferable to be overcautious and to remove a politician who could potentially be corrupt than it is deleterious to remove that politician when they maybe not deserve it. Moving to the second best politician is not a massive harm. Keeping in power a politician who is corrupt and who does take away people's rights is an extraordinarily large harm, which is precisely why, as a principle, we should prioritize caution and we should be willing to strip politicians of certain rights to protect those of average people, to criticize those in power. Which is why we explain that 1, in order to balance the scales of the undue rights that politicians have in the status quo, but two, for the simple reason the defamation is offered to people who cannot defend themselves in other means against these defamatory claims, which are of course not politicians who have a numerous set of abilities to defend themselves against this defamatory claim. You should believe at the very least it's unimportant for politicians to have these rights, if not a necessary harm. Next, I'm going to explain why it's not the case that you unlock the floodgates of a bunch of bad information coming out on side Affirmative. First of all, we would point out it is extraordinarily easy to engage in character assassination even when the tort of defamation exists. Because as we explained, you exaggerate truths, things that the tort of defamation does not pick up. It is done by those with resources to dig up all of the evidence that they could bring in order to defend themselves in a defamation case. Look at how much of this character assassination happens in the status quo and ask yourself if you think the tort of defamation is effective. But second of all, even in the worst case of side negative, when this is a totally unfounded, when it is a totally unfounded claim, we would explain it is extraordinarily easy for politicians to engage into disproving this, because they have the resources to find the evidence themselves, but also because they have the platform to do so. Again, it is unclear why this defamation proceeding is good at fixing that problem. But third of all, we would just explain that politicians can afford being sued, and that's because the most persuasive mechanism Eleanor gives you about why defamation stops information being released is the chilling effect. Is the fact that it causes a huge amount of monetary loss for the institution which is being sued. The politicians that side negative is worried about can absorb that monetary loss, which is precisely why defamation is not an effective deterrent for politicians who wish to engage in this kind of character assassination. But we would explain it is an extraordinarily effective chilling effect on those who would share information which is necessary to unseat politicians and necessary to engage in effective discourse. Because we explain that a set of extraordinarily important stories begins with very spurious info that attracts more evidence and attention. The first lead in a case, which leads to more people coming out with their stories and with their evidence of wrongdoing by the government. It is done by often outlets who are too small and weak and who cannot afford 4-year-long proceedings under side negative. But also, the kind of proceedings that stop the information from escaping. That means that when a gag order is implemented on producing the original news story, no one comes forward with evidence for this news agency to defend themselves in the defamation proceedings. Which is precisely why, as Eleanor explains, when the scale is tipped towards the politicians, they are more likely to lose. But finally, we explain a set of ancillary damages. Because, for instance, the remarks of judges which are made about these institutions during the proceedings, even if they do not lose in the end, still does a huge amount of reputational damage. The fact that the locked door keeps the politicians in power in this intermediate period, where they can do a whole lot more damage, where they can continue to strip people's rights away, is incredibly important. And maybe you believe there's only 1 or 2 instances of these news stories being shut down. We would explain that these are huge shifts. These are things which can genuinely address long entrenched corruptions, and is the only avenue around the blanket of silence that politicians have power to implement in status quo. We prove that these defamation proceedings are brought a lot because politicians have the power to do so, because even if they don't win, the fact you can shut it down for the period you're in power is the reason they bring it. You do not need to win the defamation proceeding, you merely need to keep yourself in power for the next 4 years. They attempt to explain that it will not be too much, and will deal with each of these at the end of the speech. First of all, they say it's different judges, not the ones appointed by the politicians. No, it's not. Politicians appoint all the judges. Just because they're more senior does not mean they're not appointed. Second of all, they say there are safeguards. It can be thrown out. First of all, how do you prove that it ought to be thrown out if you do not have the evidence to show that it was not defamatory, as we explained to you at first? But second of all, what judge is going to have the audacity to throw out a claim brought by the politician that pays their wages? Third of all, they say that when you lose, you look silly. We explain that you lose after you're in power, and that is not the point. The fact that you stay in power in the period that the case is running is exactly the harm. Fourthly, they say that, well, it wastes time. The politician doesn't have to be there in the case. They're happy for this proceeding to be running and keep the news company in the case while they continue to ruin the country. Fifthly, they say that it's hard to prove that this is untrue. That is the reason that it's hard to defend yourself in defamation proceedings. These companies cannot bring the necessary evidence. Finally, they say that your defendants are rich. No, you merely want to shut them up. So proud to propose.
Affirmative team's principle, which is essentially the claim that politicians trade in the set of rights which constitute the right to bring an action in tort under defamation in exchange for certain privileges. They say there are 2 privileges. The first, they say, is the wide variety of legal immunities that politicians enjoy. But I would genuinely ask these guys what they are talking about. Parliamentary privilege refers to your right to debate freely in Parliament, and if their claim is that the President is immune to prosecution, someone should tell the Supreme Court of the United States to stop thinking about the case because these guys have sold it. This is a fiction and it's not a privilege that exists. But secondly, their claim is that lawmaking is a privilege in and of itself, and by virtue of lawmaking, you give up your rights to be protected by defamation law. But there are 2 problems with this. The first is that they misunderstand what a right is, which is that the right to lawmake isn't bestowed upon politicians by virtue of some privilege. They are elected and continuously held accountable by election cycles, which explains to you that this is a right earned, not a privilege granted which requires something given in return. And secondly, I'd point out for their most grey versions of the politicians are too inside the lawmaking system. There are obviously conflict of interest laws which prevent, for instance, judges you recently appointed to hearing a case that you are bringing for defamation. I would also point out it's very rare for politicians to even do this sort of thing, but, just as on a point of order, that conflict of interest certainly would not be allowed to occur. But I also want to note here the detail in Iris's speech which goes missing, which is the scale of the actual harm which constitutes why we defend defamation defamation is so large when it comes to politicians that even if you're not convinced by my rule of law argumentation, it's unclear whether it's a fair deal for politicians. That is to say, Iris explains to you, it's not just a loss of reputation in an abstract sense, but often the loss of, for instance, business or media opportunities, the sums of millions of dollars. It's the experience of threats to your safety, threats to the safety of your family and friends, and the spillover to all the people you are associated with. That is to say, if you're accused of corruption, it's much more likely other people are viewed as guilty by association or called into question. And these people, even if you don't believe the rest of my analysis, are certainly not recipients of any form of legal privilege. Obviously, politicians aren't the most sympathetic stakeholder, but even if you don't buy the ethical reason why they have rights and the rule of law provides, certainly the people who are victims of that spillover and the quantum of the damage that they experience should be reason enough to side with the side negative. The second thing I want to deal with is the only other argument they have, which is that slap/gag suits are really scary. They are vanishingly rare for 3 reasons. The first reason is that the elements are extremely hard to make out. And it seems like there was some confusion in the first response from the affirmative team, because it's not that the claimant or the defendant has to make out the elements of defamation in the negative. The alleged victim of the defamation is the one who carries the burden of proof. That is, the politician needs to prove that the claim was untrue, they had actual harm to their reputation, there was willful ignorance or some form of recklessness. I think what they're referring to is the additional requirement for a defamation case to be successful, which is that they overcome the defenses which are available to the defendant, things like truth, public interest, and reasonable precaution. Importantly though, those are defenses which apply in their favor, not things that the defendant needs to prove in order to succeed. You can fail to prove every defense, but if the claimant fails to make out the case in defamation in the first place, you're still found not liable, even if your defenses don't work. But secondly and importantly, slaps are so risky and undesirable that media will generally be confident that politicians will not use them as a tool of suppression. That is for 4 reasons. Firstly, as Iris mentioned, vexatious litigation is easily thrown out. And the detail I want to add here is that vexatious litigation isn't like a common parlance term. It's a term defined in law which courts are very good at identifying. And importantly, the cost of bringing vexatious litigation is extremely high. So it's not just that you get fined, you also have to pay for the opposition's extremely expensive lawyers. And you look like a nitwit for abusing the legal system in front of everyone to try to get someone who is clearly speaking the truth to shut up. Secondly, we point out if the alleged defamation regards a crime, for instance, in many high-profile cases in Australia recently, you run an enormous risk. Because if you were to be accused of the crime, you benefit from the protection of the burden of beyond a reasonable doubt. But by bringing a slap action, you are now fighting on the civil ground of the balance of probabilities, which you are much more likely to lose, such as in the case of Bruce Lerman. And everyone thinks you're guilty as soon as that occurs. So in the worst cases of potential accusations made against politicians, we point out those set of scenarios clearly fall to our side. Thirdly, we point out that the claimant has to spend what sounds silly but is important, a huge amount of time in these courts where they forego the opportunity to campaign if they're a politician, where they forego the opportunity to fundraise, because they're locked in courts for sessions upon sessions for long periods of time. And we note, typically, the longer a politician appears in court, the more guilty they look. Because the more solemn photos of them at the stand, the more slip-ups they make, the more the public can pick them apart. And finally, we point out the Streisand effect actually means you amplify knowledge of the thing that you claim is defamation. So even if you eventually somehow slap the person, everyone has heard it, and it's unclear that just proving the defamation occurred would stop it if there is some merit to the case, right? The final thing I want to say on slaps is that they are not effective threats, which is how these guys have tried to say, well, we're more clever. They're actually just threats. We wouldn't actually do it. Firstly, defendants can almost always afford to fight when they know they're going to win, which is the premise from the vexatious litigation stuff, right? Because almost always, we're talking about media conglomerates and influential people. Only those people are capable of defaming a politician to the point where a slap suit would be brought. If we're talking about local news media, a politician, it's not worth it to bring a slap action against them. But also importantly, the person you're suing needs to have money for you to win. Otherwise, there's nothing for you to gain. That is to say, the law cannot draw blood from stone. So if the party you're suing isn't rich, there's no gain to be made. That's why almost always we're talking about media conglomerates, big insurers, so on and so forth. But even if you don't believe all of that, we point out that vexatious slaps will generally be fought on contingency by large and expensive law firms on behalf of smaller media organizations where it's clear the slap suit is bogus. Contingency just means no fee paid up front because the law firm is so confident there's a high chance that they'll win, so they're willing to just take a share of those winnings, for instance, getting paid costs in exchange. I think slaps are out of this debate. They are vanishingly rare and increasingly so. We win on smear campaigns because we prove a series of meaningful tipping points. The first thing we explain, and this is directly comparative against what Sam tells you, is that the range and extravagance of smear is enormously increased under these guys' side of the house. I think it's telling that their example of the, damning smear campaigns that exist under our side of the house is calling Joe Biden sleepy. We'd say now these guys legalize calling Joe Biden a Chinese spy, calling Joe Biden like a descendant of Hitler. Like that is all legal under these guys' side of the house and is clearly meaningfully distinct in the level of harm that can occur. But beyond that, we also prove in Iris's speech a series of important tipping points which create new and worse forms of defamation. So even if you believe their claim, which is like Sleepy Biden is so bad, we say on top of that, being comparative, they also legalize a range of other forms of defamation. The first is they lose the ability to get injunctive relief. So even if you believe their claim, which is like, oh, defamation cases take ages to pursue, so protecting yourself is hard anyways, the injunctive relief is what you do to protect yourself, and you can't do it if there's no tort to sue, as the basis for the suit. Secondly, we point out this opens the doors to different actors doing the defamation. So at the moment, the only forms of serious defamation that people get away with is like small anonymous blogs online. Now we point out MSNBC can slander Trump, Fox can slander Biden, and the scale of the level of that misinformation is a relevant difference. And finally, we point out courts can no longer settle the truth. That is to say, courts are generally impartial. They have a series of rules to ensure that it's kind of pretty easy to figure out what is true, and they are generally believed by the public, and the results of high-profile defamation cases are widely reported. The counterfactual to these guys' house is MSNBC says, Trump is a bastard, Fox says Biden is a bastard, and no one knows who's right. Our side is the side of truth. Vote negative.
All good to go? The negative team relies on you believing an implausible narrative. They rely on you believing that politicians have a big-ass fuck-off stick to tell people to shut up when they want them to, but they just don't use it because, I guess it would look kind of bad. The reality of this debate is an extraordinarily simple one. Politicians have a power. They have a power that they can use to great degree and create leverage, even one that can be exercised, the very threat of which is often enough to silence plausible accusations against it. And that very power is the sort of thing that means politicians are able to get away with far more than they actually should. And I'll note, even in our worst instance, if you genuinely believe that every single defamation case that happens are only kind of the legitimate ones, and that there's been heaps and heaps of negative claims that come out, I'll note, our side just gets the serious claims that happen way faster, right? Because they get leaked to the media way before they get released to the public, far before you would meet the evidentiary burdens you would need to if you were actually to have the risk of being brought into a defamation suit in the first instance. And I would argue, when this debate is talking about things like corruption, when it's talking about corporate interest, having information available to the public at all, early as fast as possible, to get as accredited and get as strong and stay in the mind of the public as long as can, is something that's incredibly critical, is something that makes a difference in politics, and is something that this team is unable to run around from. That's how we're going to take this debate. I'm going to do three things in the speech. I'm going to talk about discourse, I'm going to talk about politics, and then I'm going to talk about the principle. I'm going to start with discourse, because I'll note, I think this is the most important claim to make and weighs over any single principle claim that I want to suggest here. Because I would argue maybe politicians have some degree of principal rights, but I would argue that's outweighed by the substantive right of every single person in the countries in which those politicians govern to live in good lives, to have access to truth and information that means they can meaningfully enact their voting preferences to high degrees of sufficiency, and that is a stronger and more powerful right because it applies to a far larger spectrum of people, the individualistic rights that politicians and their families potentially have access to, which means I think if we prove that we meaningfully better social discourse, we just do win and the principle falls out of the debate. Their central claim around this is viewfold. I'm going to deal with it accordingly. The first thing I want to respond to is their claim that, well, defendants will fight if you know you're going to win. And so in the instance of like, you're not actually going to like target, like politicians will push back in the instance, and target these cases only in the instances which they think they're legitimate because they have so much to lose otherwise. But I'll note, this is just not the case, right? The actual defamation suit does not need to happen in a large number of instances where this occurs. This team acts as the only people on just these massive media organizations who have absolutely nothing to lose. But I point out, one, they often do have lots to lose because it takes up huge amounts of time and money and waste resources on the stories that you have to publish as well. But I note, secondly, often it is the individual journalist who is responsible for that story who is the one who gets lynched in these particular instances, because they're the ones who put the real risk on the line. Like, it's not Channel 10 who was at risk in the defamation suit if they were to lose it. It's Lisa Wilkinson and the journalists who were involved in the initial story itself, and those are the ones who caught the harm rather than the institution itself, which explains why people are unwilling to go ahead with these cases in these instances. Cool. The next thing I want to deal with is their claim about smear campaigns. They basically say two things about how this impacts discourse. Firstly, it increases the type of smear campaigns that exist because you get far more larger, scandalous claims published, and there's no way to punish them or gain compensation particularly meaningfully. I'll note though, smear campaigns already happen in the status quo, and I would suggest, really crucially, and something that this team misses, people are already pretty good at determining in smear campaigns what is the actual value part of the smear campaign to take away from. Like, I would note, at the point you smear Albo for being like really irresponsible with money, right? People look at the economic record rather than just kind of the big powerful rhetoric that's used. And I'll note here, this necessarily creates a kind of moderating effect on what this negative team wants to do. Because just the more and more scandalous the claim is, the less likely that people are actually going to believe it. And I think at this point when this team's like, Joe Biden gets pulled a Chinese spy, like, let's be fucking real. Anyone who believes that claim is not someone who was voting for Biden in the first instance. And that's the important thing, right? Because you can lie as much as you want, but if it meaningfully doesn't change people's political preferences in any way, that has no fucking impact on the discourse, and so it does not matter. But the types of things that are suppressed, the types of things that do not happen, the types of things that get threatened with defamation are probably the types of things that would meaningfully change people's preferences because of the fact that they are well evidentiated, they are substantive, and do actually target at the core of like what a politician claims and what they believe in a way that I think is far more significant. And even just having those out earlier, to sit in the discourse for longer, to be able to get more information behind them, is something that I think really allows it to have a more permeable effect on the discourse in a way that's more substantive and increases the likelihood that people have engaged with that information, seen that, and be able to make good decisions out of it, which I think is incredibly important, being able to engage in for achieving our benefit and showing that there doesn't have a huge amount of much. Because notably, I'll also note there is obviously a massive risk in having the person who is literally lying on the outside of the house. Like, obviously a big name media organization just spits out a bunch of fucking lies about a bunch of politicians. People probably just stop reading them because you think they're biased and you think they're shit. And the ones who don't probably wanted that kind of content anyway in the first place, and you're just kind of discredited into a wider perception of what is going on. Like, I actually think that there is a sufficient amount of moderating forces in the world to suggest that just because you get rid of the tort of defamation doesn't mean that all of a sudden everyone just says the most scandalous shit you can say. Because obviously politics is a game of persuasion, and that shit's not fucking persuasive to people in the first instance, right? Which means I think it's really unlikely that media companies or other politicians in elections or out of are going to engage in the kinds of tactics that this team says in their worst instances. But I'll obviously note this is an additive effect, right? So maybe you do this once or twice, but the more and more you do it, the less and less reliable you become, which is why I think it's important that people are likely to be particularly discerning in their use of this or do it when it's particularly effective. The second thing that I'll note are smear campaigns are an instrument for political success. So to the extent no one believes them because the lies are too scandalous or too outrageous or the defamation is literally just so much, that means that they're not going to use it because it doesn't the political tactic that is driving it doesn't actually meaningfully succeed in the first instance. And notably, as First Negative literally concedes, the people who believe these campaigns are just the people who most likely hate these politicians already. The ones who like that politician probably would disagree with it. And the ones in the middle probably aren't going to be persuaded by the most scandalous types of behavior. Which is why the set of information we describe, the ones that are more positive, the ones that do have substantive backing behind it, but would absolutely get rinsed and sued with defamation, or be published by someone so small who'd be outside of the establishment and get screwed over. Those are the type of people who are far more likely to resist and far more likely to succeed in the world that we describe, which I think is a fundamental good. Finally, I will just point out that audiences learn and adapt to this kind of stuff really well, right? So just as in the sense of the status quo people have gotten good at figuring out how smear campaigns work, I would suggest that this would probably also happen as well. The more this is saturated, the more people learn to sift through the bullshit, and I think it's pretty important. Let's talk about the principle then, because they want to suggest that this is an incredibly overriding principle that is just something that cannot be taken away. But I'll note, I think they really straw man our case in order to do this, right? Because our claim is an extraordinarily simple one. It's just, you get power as a politician from the stronger your reputation is, so you should strip of the capacity to defend that beyond reasonable doubt to the extent that you perhaps have more power than people going up against you do. I just think it is true that if you're a politician in office, you have far more resources and far more capacity to engage in things than like some random journalist, some small media company, or frankly even a large media company who's likely engaging in the publication of these stories. Especially when the most meaningful instances are often things, for example, like individuals coming out and giving statements against politicians, who are obviously the type of people who probably have the most serious information, but the ones most likely to be gagged and most likely to be shut up by then. We think that these kinds of people who are often victims coming forward and they're getting lambasted by the legal system is an inordinate harm. They have three responses to our principles to suggest they can get around it. The first they suggest is like, oh, well, there's immense scrutiny on politicians already, and so to that extent, it's unclear why it's the case that the system is so stacked in their favor that we need to abolish this right. But oh no, this just obviously isn't the case, right? To the extent that politicians get away with massive amounts of crap all the time, they are the ones who control the institutions and hold the eye on them, so to that extent it's unclear. But also we point out the system stacks in its favor even further, right? Like there'd just be more scrutiny if we would get rid of this, because we'd be able to publish more things and have that scrutiny be visible to people without being punished for it. But secondly, I would also note, scrutiny doesn't matter to the extent it doesn't manifest in actual accountability, and that's the problem. This scheme can suggest that there are lots of balancing acts on politicians, but to the extent that doesn't meaningfully result in anything or actually create an incentive for them to engage in more better behavior, I would suggest then that means that principle of balancing of power that we described simply isn't sufficiently met in their side. The last thing they say is, well, there's massive capacity for spillover, like families and stuff being harmed. But oh no, this happens in the status quo. Politicians engage in the risk and know there's a possibility of this happening when they sign up. And I would suggest that often happens already to the extent of current smear campaigns and individuals going after these individuals. So to that extent, I think you're asked, if the system is so weighed in the favor of the people who run it in the first instance, perhaps it is reasonable to take away one of the few tools that is used to silence powerlessness, and ultimately is not even something they particularly need for the instances which this team wants to describe. So proud of them.
Three parts to this speech. Firstly, on why side affirmative cannot win the debate, and then secondly, the two ways negative must win the debate. AF relies on a singular harm in this debate for them to win. They need you to believe that defamation is a tool that politicians can and will use to avoid scrutiny. And in order for them to win, they need you to believe that this is a tool that politicians can use easily and frequently to quash any accountability and capacity to hold them under scrutiny. What analysis do they give you to believe this claim? Firstly, they say politicians can use gag orders or draw out defamation suits in order to prevent a story from getting out. This does not make sense for three reasons. The first reason is that it's incredibly hard to get a gag order. Generally, the only reason the court will grant a gag order is because information described in one piece of litigation would prejudice another piece of litigation, and generally only if that other piece of litigation is a criminal trial. So think about how, for example, a pill case was an instance where that might occur. It seems very unlikely that would be the case in any defamation trial basically ever, so it's unclear that this would be a particular issue. Secondly, in order for a defamation suit to take place, the defaming statement has to have already been made. So the gag order is kind of useless, right? That it's already in the media, people have already made the statement. Maybe you can prevent people from making the statement again, but it seems like it's a bit late to put the genie back in the bottle. This seems like a very ineffective way of preventing people from criticizing you, and surely there would just be new forms of criticism to make. But thirdly, drawing out the case increases the attention given to the case, and therefore the original statement made about the politician. So this seems like exactly a counterproductive mechanism of reducing the amount of thought that people give to what might be a fair piece of criticism about the politician. So you ought to discard this line of analysis from the affirmative team because it doesn't hold up. They have a second line of analysis, which is to say politicians can use the threat of defamation to prevent people from reporting on them. Firstly, it's very unlikely defendants would be cowed by the threat of litigation for three reasons. Firstly, we point out that defendants are very likely to be rich and therefore can just afford to defend the defamation suit. Why? Because think about who gets sued for defamation. It's celebrities, it's media companies, it's people who actually have the reach to make a defaming statement. If I said something defaming about Joe Biden, 3 people would hear it, it would have zero impact on Joe Biden's reputation, you wouldn't even know it had occurred. In order for something to actually get to the point of harming your reputation, which is like a required element of the defamation lawsuit, it has to have been said by someone who has some level of reach. And even if, I said it and it got picked up by the news, it would then be the news that got sued, not me, because why'd you go after me? You want to stop the news from spreading the information, not me from saying it to like 3 people in a room. That would be useless. Secondly, though, because there's private litigation funding, that means that even small institutions, as Affirmative suggests, not sure why the UTS DebSoc is engaging in defamation, but okay, even if it was to be them, we'd suggest they could get access to private litigation funding. And thirdly, lawyers would be jumping to take a case like this on contingency, particularly in light of the number of failed defamation suits that have occurred recently that have had very large payouts for the defendants in terms of adverse cost orders. So you all believe that defendants won't just be scared by bogus forms of defamation lawsuits brought against them. And therefore, you all believe that these lawsuits probably have to have at least some merit. We then explain that it's very likely the court system is well placed to adjudicate the merit of those cases. The fact that there's a high burden of proof, the fact that there's a lot of elements that you need to meet. You need to prove the statement was untrue. You need to prove actual harm to your reputation, not just that it hurt your feelings. You need to prove it wasn't in the public interest. You need to prove that they didn't take adequate precautions in order to check the veracity of that statement. Secondly, courts will throw out vexatious lawsuits. You'll get adverse cost orders. You'll be fined. You'll look stupid in front of the world. And thirdly, there's conflict of interest laws that mean that their claim that well, you'll appoint the judge and then you'll use the judge just don't work. Additional checks and balances exist, like judges tend to be appointed for a lifetime, therefore they don't need to care what you do. Often, most countries have non-partisan judiciaries. The US Supreme Court is obviously a very substantial anomaly. And even then, considering the number of times it has ruled against Trump, ought to indicate that those other checks and balances are in fact quite substantial. So, even if you believe none of that, here are 5 additional reasons why politicians would not want to abuse defamation lawsuits. 1, it's like you get fined if you do this, it would be very expensive. 2, there's a time cost. You have to spend lots of time testifying in court, which you'd rather do campaigning or electioneering. Thirdly, it's incredibly stressful, takes a lot of time. Fourthly, the Streisand effect means the claim becomes far more, well known, and if you then don't win the suit pretty, devastatingly, you're likely to have your reputation hurt on net by engaging in the lawsuit. Fifthly, the adverse cost orders, and sixthly, you look guilty if you lose. Like, think about the Bruce Lerman case. He could have just lived his life. Instead, by losing that defamation case, now everyone thinks that he's far more guilty than they would have in the counterfactual. So all of that ought to suggest to you that not only does Affirmative's benefit not stand, the exact opposite is true. This is a tool that would be terrible to use unless you were sure that you were going to win, unless the case was very clear, which is why the sole benefit Affirmative has in this debate cannot stand. Weigh that now against the substantially unchallenged material that side negative presents to you. The first argument we make is that principally politicians have a right to this tort, and you ought not strip them of that right. And note that this should not be subject to the utilitarian calculus that side Affirmative attempts to do so. The point of a right is it's something you're entitled to do regardless of consequences. You have a right to defend yourself even if it is bad for other people, even if on net it is not good. They give us 3 reasons to challenge that this right should exist. Firstly, they say politicians get privileges, so it's fine to impose conditions. This is true, but it's not an explanation as to why this is the condition that should be imposed. We could say that politicians get privileges, therefore should be allowed to punch them in the face. It's fair. They get something, they give something. But it's not an explanation as to why that is the fair and reciprocal condition to impose. And we explain that it is a bad condition to impose, because it's not just bad for the politicians, it's bad for society. If you believe this team that politicians trade in their reputation, that is an explanation as to why their reputation is important to not just politicians, but society, to democracy, to government, and therefore inaccuracies in that reputation are bad for everyone. Taking away the one tool that exists for politicians to check misinformation about their reputation would be bad not just for them, but for everyone else. Their final reason is just to say we should err on the side of caution and maybe throw out some good politicians if that's what it takes. 1, you should care about individual rights even of politicians. 2, there are third-party effects. We explain this is not just about politicians, it's about their friends, it's about their families, it's about their children. All of those people are also affected. Maybe they should not be thrown out with the bathwater. Finally, though, we would note that this is likely to be a very chaotic process. It's not just like, we just throw out the bad politicians, it's okay. Like, throwing a politician out means a change in government. It means chaos in the way that a country is run. It means huge devastation to the provision of services, to the ordinary continuance of the way that that country operates. This is not something to take lightly, and is not something that ever fully defends. The impact of this was very large. We explained to you that this was a principle that meant these people were entitled to a right, that reputational damage was a real harm, and that we would not allow those harms to occur to politicians in other ways. We would not make it legal to rob politicians or to punch them. You should not make it legal to harm their reputations. It wasn't just about harm to politicians, it was about the harms to everyone in society. Finally, we explained that this in fact makes misinformation worse. flipping the claim from side affirmative. We explained there are 4 ways that the capacity to smear politicians gets substantially worse. Firstly, there is a greater range of stories you can engage in, because you don't need the kernel of truth that might be defensible in court, you can make up anything. Secondly, you can't be forced to stop, because a court can't order an injunction to say stop doing that story, even if it's very wrong. Thirdly, a greater range of actors now participate. At the moment, bloggers write whatever they want about Joe Biden, but now, mainstream media outlets would feel free to report on his claims because there's nothing that can be done to stop them from doing so. And finally, there's no objective arbiter. The courts can't come in and say that is false in a way that people actually believe. There's no free publication of the fact that someone has won a defamation lawsuit and proved a claim untrue.
First, slaps and gags. Second, easy wins. Let's start with slaps and gags. I want to start by acknowledging that the burden of proof for this team's argument about gag orders to succeed is exceedingly high. Because unless, as Udai puts it, they can prove that these legal tactics are used frequently and easily, our explanation that this is so patently anti-democratic and so patently evil that it ends your political career stops this argument before it even starts. Because even if politicians can trample down a couple of news stories here and there, the benefit they get from that is trampled over 1,000-fold by, in the common law countries where defamation is cause of action, looking like the first dictator in what are historically republics and constitutional monarchies. And famously, even people like Donald Trump have stopped using slap and gag tactics after coverage by programs like Last Week Tonight, showing that even the people with the most disrespect for those norms and for those narratives are subject to the idea that you can only go so far. With that mountain to climb, we give you the list of reasons why slap and gag orders are very risky and why they're unlikely to be done. I'll save you repeating them. The best response we get to all of that material from third speaker is to say, well, we'll just disprove it in public. We don't have to use court systems to gain the benefits you describe, and so we're okay just like you. But we preempt this very easily by explaining that the problem with beating allegations in the public eye is issues of spin, issues of ambiguity, like for instance flagging something as only mostly true or mostly false rather than coming down as a determination, things like echo chambers, things like public partisan interests only listening to the sources that they believe, make it exceedingly difficult to understand exactly what their remedy to rampant defamation is, which explains to you why, in the absence of the list we described, in the absence of the argument that that list defeats, this team doesn't have a leg to stand on. And the final way I want to sum this up, because I know it's a confusing argument, is ask yourself whether Fox News or any other media enterprise of an equivalent size or a single politician trying to abuse the legal system has more resources to fight, better connections to make their message heard by the public, and therefore who has better odds at winning. It explains to you why it's so unlikely that these slap or gag orders are ever used effectively, and why therefore the only harm this team has falls out. The reason I named my second issue Easy Wins is without slap and gag orders to weigh against, the degree of response to our claims is surprisingly minimal. For instance, on our principle, we explain that defamation exists to protect people and that those people matter. And even setting aside my blusterous defense of liberalism and the rule of law, my team at least paints a pretty grim picture of the harms that defamation law exists to protect people from. Stuff like millions of dollars in lost business opportunities, death threats being levied both against politicians, but also their friends, family, businesses, and political parties. Against the weight of those harms and that analysis, the only response we get is politicians opt into those things. But importantly, our analysis doesn't explain that politicians don't know about these risks, but that these risks would be unfair to impose upon politicians for, as we explained, very few true privileges that they enjoy, as opposed to roles that they fulfill within government. CF, the punching in the face example that Udai provides. The second harm we explain are smear campaigns, where we explain a series of tipping points are reached where you no longer have legal protection to prevent them from occurring. Stuff like them becoming more varied and targeted, stuff like them becoming harder to stop and fact check, and widening the number of actors capable of delivering a smear campaign effectively. The response to that relies on, I guess, the fairly extreme examples I provided in my speech, which is to say no one would believe that Biden is a Chinese spy. But ask yourself whether there is any story which is false that a Trump voter who could have been convinced not to go to the polls would believe. Ask yourself whether the average reasonable American truly can see through all the lies concocted by media empires and professional liars, and by doing so, you see how we take the debate.
There is that speech. After reply, conclude the debate. Here.
It's telling that they spend the vast majority of their speaking time simply defaming our case, because the first question you should ask yourself is, do they actually prove this is effective at all at stopping smear campaigns? Because they would need to prove that this is meaningfully effective at stopping smear campaigns for this argument to matter, which is a harm that is never proven. We point out three crucial responses which go ignored. First of all, we point out that the most outlandish claims can easily be disproven. Second of all, we point out that the kinds of people who make these claims that are smear campaigns do not actually care. The Streisand effect Neg tells you about is the reason Joe Biden would never sue anyone for calling him a Chinese spy. They neatly explain why it is that no one would ever sue a smear campaign. But third of all, we explain that often these smear campaigns are not in fact defamation and thus cannot be brought in the case because they are from followed up of deep investigations into family history, exaggerated claims that are in fact based on truth that would avail the defendant to the defense that Dan talks about, which is the exact reason you can do smear campaigns even in their world. Joe Biden has been called a Chinese spy. I saw that on Twitter. And all of Udai's analysis about why you can't stop information getting out is the reason that defamation proceedings are not effective at stopping smear campaigns. So, even if they prove a marginal benefit, ask yourself, what is the harm? Who is being persuaded by the fact that there are slightly more aggressive and slightly more spurious smear campaigns? Absolutely nobody. They do not have a harm. But secondly, they fail to prove this is actually a right that politicians deserve to have. Because they argue that, well, these politicians lose job opportunities and media contracts as a result of this defamation. But as we point out, they only have these rights because they're in political power. And what we explain to zero response is that their reputation is a ticket to hold their power, and it is a risky ticket to leave it in those hands, which is why we always tend towards taking it back as opposed to leaving it in their hands. Because double entrenchment of this right by giving politicians an ability to defend their reputation is problematic. We explain the rights of all are far more important than the one, that is the rights of everyone to criticize their politician is more important, because the politician is only in power because of the consent of the many, which is exactly why you should care more about the ability of the many to engage in criticism of a politician than you should about the politician's rights. Their argument for why politicians have this right is entirely contingent, because they argue that politicians have a right not to have their reputation tarnished, which would be contingent on them winning the first question of whether or not this stops politicians' reputations being tarnished, which they do not. But we prove that this is a non-contingent principle about a fair system, which is not skewed towards benefiting politicians who already control levers of power. But finally, their response to our argument on gag orders is totally insufficient. They talk about vexatious litigation. They talk about looking like an idiot. They talk about having to go to court. We explain very simply that these proceedings are likely to be successful, because the fact that the politician's reputation suffers inherently proves the initial claim that means you can't throw out these proceedings. That means it will drag on. The fact that the defenses are so hard to raise because you can push the burden on the defendant to demonstrate what evidence it had to make that claim and shut cases down in the earlier. You make life easier as a politician to continue to do bad things. Politicians who are already incredibly good at hiding things, which is why the world is so finely in the balance of being able to call them out. Because you lock the doors while the politician is outside, because they don't have to attend these proceedings, even though the company who talked about this does in fact have to be there. You drag and you slander the publisher as long as they're in court. And maybe you lose eventually, but the problem is that this politician is already in power. They have already won again, as long as this company has been locked behind the closed doors of the court. But this case prevents a set of other crucial benefits, of other publications who are able to focus on and reiterate this piece and bring their own evidence, and the fact that the court will continue to shut down similar talk and similar statements which are currently subject to that defamation proceeding. But crucially, this debate is not just about Australia and the US, it is about context where these politicians do hold a significant amount of power over the judicial system. Of course, vote for the rights of the many.
Hi everyone, thank you very much for the debate. I've been wanting to set this motion for ages, and I finally got to do this comp, and I was not disappointed at all by the debate. I really enjoyed it. It was quite a close debate, quite a high quality debate from both teams. The whole panel found to be very good and quite enjoyable. A couple of general feedback. The first is, I just wanted more examples of how it's actually happening in the world at the moment, because like, even in the Australian context, Christian Porter, John Barilaro, the names went out of my head, Linda Reynolds, they're all using this defamation stuff at the moment to varying levels of effectiveness. I think that would be really interesting to see how those are played into the debate, whether they have had the effects we want to have in the debate. I think secondly, a bit more discussion around how compensation works in the meantime, is like the outside of court settlements, whether or not that impacts the debate as much as well. I think the third thing I want to say in feedback is I think obviously everyone in the debate is very smart, and a lot of law students in the various teams, but a lot of jargon was thrown around, not necessarily that jargon being explained. I think one of the claims that was heard was like, what is an injunction during kind of discussions? So things like that I think is useful to actually explain, because you don't want to run the risk that the judge won't know what you're talking about, or particularly going into austral season is from a circuit with a different judiciary system or different terms and won't necessarily know what that means. So just making sure we explain the jargon and explain the terms. In terms of the result then, I guess the panel as a whole was split 2-1, but the voting percentage of the panel was unanimous in awarding the debate to side negative. So congratulations side negative on a close split win. So that seemed like the easiest way to explain the decision. In terms of the decision then, as I said, we'll be a little bit brief because we're pushed for time, but I'll do my best to cover the debate as best I can. The first thing I want to look at is this question of, I guess, principle. Should the government have a right, politicians have a right to access this? I think AF's best material here does suggest that politicians have a number of rights that exist to them that maybe overpowers them in some respects, and that might therefore be justified to curb those rights, because they have access to more power to defend themselves, they have the right to speak in Parliament on issues, etc. And being removing this power of defamation seeks to somewhat balance the scale. I think we're convinced by the response from negative that there are actually lots of ways you could balance the scale. It's unclear why this way in particular is the best or most appropriate way to rebalance that power scale, particularly when, as they prove in practical issues later on, it is also an important and valuable asset for these groups to be able to access and protect themselves from harms that occur to their reputation or things that are said badly. There are some other more practical considerations we get, well, they're not practical, but like other justifications we get from AF as to why it's principally unfair around the additional power that they have, such as the power to appoint judges. I think that is pretty well pushed out by negative as being likely not to happen in lots of circumstances, or had the amount of power they want to, given like lifetime appointments, conflicts of interest, etc., meaning you're probably not going to be having access to the same judges. They then tell us about, well, you have access to power and connections. I think the problem with this material about connections is, one, I guess as an OIV, I'm not sure that you can just hire the Solicitor General to act in your personal defamation matters. Even still, even if you do have those connections, if you're making an unsubstantiated claim or an unsubstantiated defamation suit, it's unclear that would necessarily be successful, despite how many connections you have if the judiciary investigates you and it works overall. So I think what this means then is, while the government and politicians do have some degree of additional power, I don't necessarily think that removing defamation is principally justified to do for these people, because I think it doesn't necessarily rebalance that power in a uniquely or important way in the debate. Let's then look at how it is used, where I think lots of debate ends up happening as the debate moves on. I think the first framing question on how it is used is to look at like who is actually involved in these suits on the other side. I think from AF we get a bit of a push to trying to create a vulnerable stakeholder, a small newspaper article, or a small group trying to crack a story and trying to get people through. I think that this, or in some cases individuals trying to break stories. I think the problem here is that like the capacity of those people to have the reach and engage in the harms we're talking about as described by, is unlikely to have the necessary reach to reach the legal burden as described by negative, because it's not going to actually have enough reach to have that power, but also it's unlikely these groups have the resourcing capacity, or the ones that are most likely to be involved in this. The second way I think neg proves this is pointing to the examples of the where it's most likely done against, most commonly done against big media organisations and media corporations that do have money and slush funds and lawyers and connections and all that sort of power as well, which I think also links to the previous issue around principles sort of actually making it not quite as uneven in the way up when you have organisations over here that are that powerful and are that big, which I think then means that these groups are ones that are likely to be less of the vulnerable groups that Affirmative is talking about in today's debate, and more groups that do have the capacity and the power to defend themselves. The second aspect of this then looks at is it going to be used vexatiously for gag orders and to sort of strike down what is being said. I think this applies to the common context of the big organisations, but can also apply to the little groups as well that Af talks about. I think the negative, the Affirmative gives us some good incentives as to why politicians might want to do this. I think, however, negative is able to ultimately flip all of those and show what would be more of a disadvantageous decision for the politicians to make to do this. Firstly, because gag orders being difficult to get in terms of like when they are ultimately applied by courts, stop publication of materials is limited to certain circumstances, normally involving cross-examination in criminal trials. Secondly, that there's always sorry, I can't read half my handwriting. So secondly, there's also a lot of like practical difficulties in actually achieving this end, so the time taken to court, the costs that are likely to be involved. Nextly, the attention is likely to be given to this in the meantime means it grows. Barbara Streisand gets a run here as well, explaining all the reasons why it is likely that it's actually going to escalate and make the decision actually a lot worse. But also the risk of losing is quite high in these cases, so you're unlikely to put in gag orders in cases where it is unfair, because if you lose, it confirms the negative things that have happened, and it makes you have to pay the cost orders and likely pay worse higher orders costs in that time as well. All that I think helps to suggest then that it's unlikely to be used in the worst and most vexatious cases that are likely to exist. And that is probably where the panel had the most split, was around those two things, like which was the types of organisations and how likely are they to use it in a way that is likely to be vexatious then. So then we come to the types of like actual claims that are being made by the alleged defamers. I think that what Neg is able to do here to say that if that claim is true, and is a correct claim that is being made, then there's likely to be strong litigant funding and lawyers who want to jump on this because of the profile nature of the case, and also because of the size of people making those defamatory claims that mean they're going to have the capacity to defend themselves and engage in that process. But if the claim is a wrong or incorrect claim, it's probably justified that the politicians have the right to take the defamation action to ensure that they can clear their name and have access to it. There are still two harms here, I think, that are the best stuff from the Affirmative team. The first harm of the usage of harm here is that then the capacity to actually publish, gather more information is significantly slowed down as a process of this, because even if you are somewhat wary of being sued for defamation, you don't want to publish things too early. I think the problem here is that like if it is a true thing, it's probably going to be okay to publish in court, and if it is not correct, it's probably fair that those things aren't published in the first place. And I think we're able to trade off, maybe there's a mild increase in the publication of some material, but if that material ultimately ends up being published anyway by the big companies that are being correct, that's not necessarily a harm. The second thing is that this idea of just getting more information out there so voters can have discussion and make more informed decisions. I think probably a good benefit is explained by Affirmative team, but given ultimately we think the gag orders are unsuccessful, that discourse and information is still likely to be able to occur in situations where that material is true and important to get out there. It likely will, so that harm doesn't also stand up, and that's why the debate in an abridged version of the OA falls to side negative. Hope that all made sense. Again, apologies for the pace. Very happy to chat later on, but again, well done to both teams. Good luck for the rest of the tournament and for Australs.